Thank you, everyone. Please be seated. All right, we'll now get to the arguments in the two final cases this afternoon. Ms. Finley, you're up again.
Hello again. Morse and CCI are two recovery actions brought by the state pursuant to Iowa Code Chapter 249A against two residential care facilities that the state alleges receive Medicaid overpayments. Through their appeals, both lenders, Bank Iowa and DeWitt Bank, challenged the district court's ruling that a receiver appointed pursuant to 249A has the power to avoid the pre-existing liens of secured creditors. I, on behalf of CCI, will address the issues of statutory construction and constitutionality, and then Joe Borg, on behalf of Bank Iowa, will discuss the common law and public policy. No one disputes that Medicaid recovery is an important state goal, and no one disputes that the Medicaid receivers should be fairly compensated, and in the CCI case at least, there are or should be sufficient assets to compensate the receiver. The real issue in both these cases is whether the risk of Medicaid overpayments can be shifted from the state to lenders. Or stated another way, did the Iowa legislature give the state, the party that made the overpayments, that has an agency charged with monitoring Medicaid and regulation and oversight, and the party that created the receivership, the power to transfer the risk of Medicaid overpayments to private lenders who had no involvement whatsoever with the Medicaid overpayment or alleged Medicaid overpayments, and have no way to monitor, prevent, or recoup such overpayments? And the short answer is it did not. The critical issues in this case are the difference between liens and unsecured claims and how their priorities are determined. Bank Iowa and DeWitt both had liens that were perfected prior to the initiation of the receivership proceedings. The state, the receivers, and the qui tam claimant in CCI all have unsecured claims or junior liens, or liens that were junior to those held by the lenders. As Mr. Borg will discuss, both the common law and bankruptcy law provide that receivers and trustees do not have any rights in secured collateral, and liens generally pass through bankruptcies and receiverships intact. The district court relied on Iowa Code Section 680.7, Iowa's General Receiver Statute, to allow the receiver to avoid the liens of secured creditors. But 680.7 does not address liens. It merely establishes priorities of certain unsecured claims and provides that the costs of the receivership are paid first, then the taxes in accordance with 680.6, then certain employment claims, then all other general unsecured claims. 680.7 is completely silent with respect to liens, and that's because Iowa Code Section 680.5 is the statute that addresses the determination of the priority of liens. And that statute provides that when there's a dispute among lien holders as to the priority of their liens, those disputes are submitted directly to the court for determination rather than to the receiver.
Correct, kind of reviewing the history, that if we go back in kind of the 100+ years ago when all this stuff originated, we had in 1899, I think we said in the Smith case that the receiver takes the property subject to the payment of all prior liens, and at that point there was just 680.5 in place, and that 680.7 was added. And so the argument could be made that really 680.7 was not intended to disturb the law. It was just intended to address unsecured debt.
I think that's exactly accurate, and it codifies what had been common law forever. Just the axiom that liens and secured creditors are in this group and their property passes through, and then after that's handled, you turn to the claims.
And this was also
creditors.
kind of the law under the old 1898 bankruptcy, the old Bankruptcy Act that was replaced in '78, right?
It was the law back then, and it is the law now. In bankruptcy, the liens of secure, you can't usually, unless you demonstrate two exceptions that Joe will talk about, you cannot disturb the liens of a secured creditor and get a plan confirmed. just want to make, don't want to take Joe's time. The state also relied on 249A-44, but nothing in the language of that statute gives the receiver the power to avoid any liens. It's also completely silent with respect to lien avoidance, and it expressly provides that the cost of a receivership will be paid by a Medicaid provider or other person. An other person is defined later as someone who participated in the alleged Medicaid overpayment. There's no allegation here that DeWitt or Bank Iowa participated in any alleged overpayment. And more importantly, the retroactive application of 249A-44 to allow the receiver to avoid liens would result in an unconstitutional taking. And the case that illustrates that is U.S. versus Security Industrial Bank, where the United States Supreme Court considered 522F of the Bankruptcy Code, which, unlike the statutes at issue in this case, expressly said that trustees in bankruptcy can avoid non-possessory, non-purchase money liens and exempt property. And the court found that the retroactive application of that statute would result in unconstitutional taking. Security Industrial also illustrates that Congress and the Iowa legislature know darn well how to write a statute that allows for lien avoidance. They simply did not do so in this case. And one other point, the state understandably wants to limit the discussion on this appeal to receivership costs, but it's important to understand what their urged construction would result in. If this court adopts the state's construction of 680.7 and the one used by the district court to allow a lien to be avoided in favor of receivership costs, the state can and most assuredly will argue on remand that its entire claim for Medicaid payments is also entitled to priority over pre-existing claims, and it would effectively wipe out, in DeWitt's case, about $3 million worth of secured collateral. And here's how that argument would go. Iowa Code Section 249A.53 provides that the state's claim for Medicaid recovery shall be classified as a tax. If you look at 680.7, it says first receivers, ship fees, then taxes, then employment claims. If that's the order and then somehow that shifts secured interests or secured liens, pre-existing liens down below those unsecured claims, it would just turn debtor-creditor law on its head. So the appellee's position in these two cases can be summed up as follows. The receivers and their counsels are to be paid hundreds of thousands of dollars. The terminated employee and qui tam claimant in the CCI action and her counsel are to be paid hundreds of thousands of dollars. And if the state's interpretation of 680.7 is correct, it expects to be paid millions of dollars. And all of these folks expect to be paid for their unsecured claims or junior liens from the collateral of these two banks. I'm going to turn this over to Joe.
Thank you, Counsel. Mr. Borg.
Thank you, Your Honor. May it please the court. Counsel, my name is Joe Borg, and I represent Bank Iowa, one of the applicants in this interlocutory appeal. Bank Iowa and DeWitt Bank and Trust are innocent, good faith lenders, and I think that's one of the most important aspects of this case that can't get lost and are set to suffer a great loss and injustice if the district court's rulings are affirmed. But we believe the reversal is warranted based on the applicable statutes, the common law, and the existing principles of sound public policy. And Ms. Finley did an excellent job setting out the statutory basis that the district court relied on. Unfortunately, 249A-44 is a new statute enacted in 2013, so we don't have any existing case law to look at to decipher it and to interpret it. But one of the things before I move on to the common law that I believe is important is the statement that the court, in the event a receiver is appointed under 249A44. The legislature stated the court shall assess the costs of the receiver to the provider or other person. And the reason I believe that is the utmost importance is the term shall, as the court has long held in its ruling, is when the legislature uses that language, it's a mandatory obligation. And in essence, what is happening under 249-44, if the district court's interpretation of 249A is upheld, the costs of the receivership are not going to be assessed to the providers. It's going to be assessed to the good faith, innocent lien holders.
I understand that argument, but wouldn't another way of looking at be this? If, let's say the tax code says I owe back taxes, they shall be assessed to me. Well, assessing them to me doesn't tell me that they get priority over Wells Fargo that has the mortgage in my home, that when the IRS chases my home, they can get priority over Wells Fargo. That's a separate issue, right? Isn't priority and assessment two separate things?
Well, in this case, I believe that it is, well, because of what the district court found, I believe that the priority issue and that it's the priority issue that the court determined was inaccurate because the court didn't undertake the balancing that is required under the common law. And getting into the case of Howe versus Jones, which I believe is the most analogous case that we have to present to the court. In Howe versus Jones, a intervener successfully got the lower court's decision reversed, which assessed receivership costs to and ahead of the intervener's property. What the court ended up finding is, even though the receiver conducted its work in good faith, the intervener established its right to the property and the receivership was set aside. Well, specifically Howe versus Jones and the other case law that I'll cite, what they look at is what kind of participant the pre-existing lien holder was in this receivership. And in reversing this assessment of the receivership cost to the property, the court stated, "This provision of the order works a great injustice and is manifestly wrong. It compels the interveners to pay the costs and expense occasioned by the attempt of the plaintiffs to have their property applied to the satisfaction of the debts." They went on to describe that these interveners, like Bank Iowa and DeWitt Bank, only became part of this action to protect their property, had no role in the institution of it, and have not received any of the benefits that the receiver has expended their costs on. Instead, the DHS and the receiver are the only entities that have received a benefit in this action, specifically as what counsel has aptly noted, that what is...
Isn't there kind of a disagreement over the extent to which your client has received a benefit? They make an argument that to some extent you did get a benefit because by having the receiver in place, the property was preserved, steps were taken to protect your collateral. Isn't that right? I mean, they make that argument. You know, it may not ultimately wash out, but they make that argument, right?
The argument is made, but then I would turn the court to the case of Frick versus Fritz, which is also an older case, an Iowa Supreme Court case of 1904. And the court in there is another intervener action where the court denied the receivership costs to be assessed to the property. And in there, the court specifically found that the interveners were entitled to possession of the property itself and to have it subjected to proceedings as they might see fit without the expense of a receiver. So, like in Frick versus Fritz, Bank Iowa and DeWitt Bank had other options available to outside of this receivership to exercise their property rights, their longstanding property rights that they had. In Bank Iowa's case, it was since 2004 that they had a secured interest in the property, and under those contractual rights, they had the ability to exercise those rights how they see fit, not relying on a receiver. So I believe the holding in Frick versus Fritz, I guess, distinguishes that and provides that an intervener like Bank Iowa and DeWitt Savings Bank should be entitled to deal with that property the way they see fit. The evidence presented at the time of the hearing in Bank Iowa's case demonstrates little to no, and I would say no benefit that has been provided to Bank Iowa. The expenses specifically to Bank Iowa's case, and I'll let Ms. Finley discuss to DeWitt when she gets opportunity to come back up. But specifically, in the Bank Iowa case, there were two separate law firms that were hired to represent the receiver, and one was just hired to represent the receiver in just based on the expertise in Medicaid administrative appeals. So there's absolutely no benefit to Bank Iowa in that instance.
Can I ask a pragmatic question, please? I understand your gloss on Chapter 285 and 7, and I understand your gloss on the Medicaid changes. But let me just ask, if a receiver doesn't get expenses paid kind of off the top, if you will that make it more difficult to get a receiver to serve at all in situations where there are liens and it looks like payment might be clouded?
And I think that's a consideration the receiver would have to make up front. And in the Bank Iowa case, the state made an exception to a rule which the state is withholding, as the court is aware, as part of their request for a receiver. The state is withholding Medicaid payments that were to go to the provider.
The receiver kind of works for you too. I mean, work for you meaning the receiver provides a benefit to lien holders, I take it. I mean, you need to, in most of these situations, the receiver marshals assets and makes it possible for orderly payments and so forth. But will your rule in a complex case where there's substantial lien holders and maybe marginal unsecured assets mean that a qualified receiver just won't be available?
Well, what I believe is that the state can make the determination. As part of the 249 action, they can ask for the disclosure of assets to see what assets and liabilities are available. And
Is there anything preventing the state from hiring the receiver out of their own pocket?
no, I don't believe there is.
I mean, if the state, and would you have an objection, I mean, if we ruled for you, if we did, to a remand that would allow the receivership expenses to be charged to your client's security to the extent there actually is benefit to that security?
I think that we obviously believe there is no benefit, but I believe the case law, at least in other jurisdictions, specifically note that there must be some kind of, if there is going to be a cost put towards the secured property, it must be equitably apportioned to the amount of benefit received on that. And here what's missing on top of many things, the district court undertook no measure to try and determine whether a benefit was given to either DeWitt or Bank Iowa, and B, what that benefit was. So what we're left with is the potential that the secured.
Does the benefit have to be tangible, or can it be an intangible benefit, like the orderly winding down of the entity, the orderly collection of assets, and those type things? Or does it have to always be a tangible benefit to you?
Now, I believe it'd have to be a tangible benefit in this case. Specifically, when I said that Frick versus Fritz, the bank or other lien holders have other options that they could undertake that are not as costly as this. What's going to happen with Bank Iowa, DeWitt, and any other case coming before it? The assets, the secured assets, are the assets that are going to get eaten up, and the secured lien holders are going to then be placed into the pool.
What prevented you from just foreclosing on your mortgage and
Well,
going and taking the property then?
And that's a very good question. There was no notice, which is another important factor in these cases. If the court is going to rely on 680.7, I believe they also must take into effect 680.1 in the receivership chapter that requires notice to interested parties. Here, the receivership, and that's one of the other problems, the receiverships were both instituted before any notice was provided to either DeWitt or to Bank Iowa. So there was no way for either entity to find out if there would be any kind of substantial impact against them. But once Bank Iowa filed the foreclosure action, which they did file a foreclosure action, they were informed because the property was under receivership, the district court would have to grant authority then to proceed with that foreclosure action. So they attempted to utilize the law in their favor, but was prevented from that. I see our time is...
A quick question. It seems to me somewhat of a elusive argument to say that you're going to have to show some type of tangible benefit in order to have the security, have some of your security provided to the payment of the receiver in this matter, because you've got the property, it's secured, it's not going anywhere. So how would you prove that you actually did receive, or how would the state prove that you did in fact receive any type of benefit, tangible benefit from their actions?
I agree. I think it would be very difficult to show, because especially in this instance, it's the DHS that has the obligation to these individuals that are in there. The receiver, within 6 days of the Bank Iowa case, the receiver decided to shut down and put in a joint motion with the DHS to shut down the businesses. So it appears that there's in the Bank Iowa case, there appears that there wasn't any attempt to try and continue on the businesses. It was just purely a liquidation, and we believe there's no benefit, which now just leaves empty buildings, which is difficult to try and move. So I believe it would be very difficult for the state to show some benefit outside of.
What effect, if say that we did rule for the receiver in this matter and DHS, what effect would that have or on lenders such as the banks that we have here, to have them continue to operate at all?
And I'm glad you asked that question. We have an amicus curiae brief that was filed by Mr. Bob Hartwig, who is in the audience here from the Iowa Bankers Association. I believe that's of the utmost importance, the public policy concerns related to a decision that would affirm the district court. And what would happen is lenders would, lenders would no longer lend to these type of borrowers out of concern of the potential for their secured property to be taken away, or B, the costs associated with that lending would be exponentially high, that borrowers would not be able to conduct business. They wouldn't be able to get the loan and make payments on the loan and conduct business. And because of the fact that these banking associations, these lenders are required to retain standards of safety and soundness to ensure they maintain the appropriate loss reserves, there's no way to quantify what amount could come if the state ends up deciding that there's been some Medicaid overpayment made. And in essence, the banks would then have to become a greater oversight entity to determine whether there's any issues with the Medicaid, which also presents problems with the Healthcare Privacy Act, and also would potentially cause issues with the concern that the oversight would create some kind of fiduciary obligation. Banks would have to be watching so closely these entities to make sure their risks, were taken care of.
Thank you, Mr. Borg.
Thank you.
Ms. Licht?
May it please the court and counsel. My name is Amy Licht. I represent the Iowa Department of Human Services, and I'd like to begin actually by reserving the last 2 minutes of my time in the event that there are questions that are best answered by counsel for one of the receivers in this matter. Chet Mellema is at counsel table and is available in the event those questions arise. In front of the court today are 2 applications for interlocutory review for 2 different Medicaid providers, and as was evident by the presentations of the appellants, 2 different parties. Because there are 2 different sets of facts, I'm going to start just with the common legal questions that are presented to the court, and the reason that these cases were combined for argument this afternoon. And I think that where the court should begin with its analysis in these appeals is the statute. Iowa Code Section 249A.44 is a relatively new Medicaid statute, and it's a statute that gives the Department of Human Services, which is, of course, the state agency that administers the Medicaid program, is responsible for oversight and recovery of Medicaid dollars, some new tools, basically, to go to a district court when it's dealing with a troubled Medicaid provider. And as this court knows, because it's dealt with many Medicaid cases in the relatively recent past, the Medicaid program in the state of Iowa is jointly funded by the federal and the state government, provides services to thousands of Iowans and deals with thousands of providers, processes many claims every day, and is a very large program. And so 249A, which was part of a relatively new set of reforms to the Medicaid statute, contained in Chapter 249A, gave the department the ability to go to a district court when it's dealing with a troubled provider and seek a number of different types of relief. And I'll just start by saying, when I say a troubled provider, the statute identifies what kinds of providers are at issue in 249A.44. They are a Medicaid provider that's under sanction by the department, that's having funds withheld by the department, or is the subject of some sort of legal action, civil, criminal, or administrative, where there are funds at issue. Medicaid funds that, in the most common scenario, have been paid out, and the department has subsequently determined they were wrongly paid out, and now is under an obligation to recover them. In that instance, the department can go to a district court and ask for an injunction to prevent that provider from basically getting rid of its assets, dissipating its assets, while the recovery action goes forward.
I understand the whole concept of a receiver. What I'm having a little bit of difficulty with is reading your requirement under 249A.44.3, I guess it is, that says that the court shall assess the cost of the receiver to the provider or other person, and how you read into that you can now sort of dip into the pocket of some other third person that's not the provider. They're a secured lien holder in real estate, typically, I assume, or in this case, I might assume that. How do you read that into that statute?
Well, I think that we look, and what the district courts did is to look beyond the statute to say that the provider is really responsible for the costs that are incurred here. And the only way, really in both of these cases, we have what are eventually defunct providers, is that we have to look to the assets that they have, because that's the way that you can assess that cost to the provider. And
that's kind of troubling to me, frankly, and I want to give you an opportunity to respond. That's a open-ended interpretation of the statutes. I mean, securities in real estate, liens, if you will, have a long history in our legal culture, of course, of preferred treatment, and they're the basis of commercial lending. To read 249A.44.3, which which doesn't really explicitly deal with the issue at all, but to read some implication into that statute strikes me as awfully muscular.
Well, I think, and that's why it made sense to look to the common law, because we think, well, our position is that anytime that there's a receiver appointed, that the receiver must be paid as an arm of the court, must be paid, as I think it was put earlier, off the top, that his payment must come first, because in practical terms, no receiver will take the job
the
otherwise.
overwhelming common law rule seems to be the receiver takes subject to the secured liens with two exceptions. One is if the secured lender consented to, agreed to the appointment of the receiver, and the other is if to the extent the secured lender is benefiting from the receiver. That seems like that's kind of the established common law everywhere, isn't it?
Well, I think, for example, under the Gallagher case, which we talk about in our brief, that this Supreme Court, a lot of these receivership cases, of course, originate from 100+ years ago when these arrangements were more common, that in that case, for example, there's not necessarily a finding that there's a benefit to the receiver, or excuse me, a benefit to the secured lender, or that there's
I grant you the Gallagher case, but there's a lot of other more recent case law that seems to say that the lien holders are priority as against the receiver, except to the extent the receiver benefits the lien holder. And isn't that kind of logical, because the secured lender has a property right that came first? Isn't that right?
Well, the secured lender certainly has a property interest that is secured, and so I think what the lenders here are saying is we had an expectation that we were first, and we all understand that that's fairly reasonable. It's not unsurprising that that's their understanding, but we think that the common law does support the idea that when a receiver comes in, that they should be paid first and before the secured lender. And I think, particularly in the Medicaid context, there's a unique reason for that to happen insofar as this is a unique situation where you have a state payer responsible, for all of the things that the Medicaid program does, that is a unique interest in the resolution of what's going on with these providers. And I think some of the cases, for example, that were cited in the briefs that were submitted by Bank Iowa and DeWitt Bank, they're out-of-state cases. For example, there's a couple of cases out of Texas that do look to that, but we really don't see a parallel that sort of overrides the older case law in this state.
Let me ask you another question. Suppose these facilities had just filed for bankruptcy, all right, when things started getting in trouble. You would agree with me that you would not be able to get at the secured liens then?
Not being, a bankruptcy practitioner, no. No, I mean, we would. I think that what the state would say is we have to take our claims and we have to go through the bankruptcy process.
Isn't that analogous? I mean, in bankruptcy, the situation would be the trustee that's kind of analogous to the receiver. Those trustee fees cannot be imposed on the secured liens except to the extent of benefit. I think that's in 11 U.S.C. 506, something like that. Isn't this analogous to that?
Well, but I think that the analogy is really, it's not, and I think I want to make sure this is clear. It's not that the Department of Human Services or the Medicaid program is getting its claim in front of the secured lender. It's the receiver who really kind of is analogous to the trustee in a bankruptcy matter.
That's what I'm saying. The trustee can't invade the secured creditor's collateral except to the extent that the secured creditor is benefiting from the trustee's actions, right?
Well, but I think I guess what I think is the important analogy is when the trustee himself or herself gets compensated for the work that he or she has done in managing the property or the assets and disposing of them appropriately, he or she will be paid for the work that he or she has done in liquidating them. And that's what the receiver should be entitled to here and should receive, because they're acting as an arm of the court. They're, as it was put, marshaling and liquidating the property.
Here's what 11 U.S.C. 506 says. Okay, bankruptcy trustee may recover from property securing an allowed secured claim the reasonable necessary costs and expenses of preserving or disposing of such property to the extent of any benefit to the holder of such claim. So isn't that kind of analogous to the present situation?
I think there is an analogy, but I also think that there's a benefit to the secured creditors here in that in both cases, what the receiver has done is taken the properties, and particularly the CCI cases is a really good example, because that's a situation where the provider, it was a very large provider, they owned a lot of property, and the receiver in the course of maybe 8 months has disposed of almost all of it, and a large chunk of it, which was really these are specialized facilities that were used for residential care for Medicaid members, and disposed of it at a pretty, I think a pretty good price is what we would say. It was 95+% of
And I
the
thought I heard
cost.
them say that they wouldn't object to the extent that there actually is benefit established to the secured creditor paying for that share of the receivership expenses.
That has not been, if that was the answer this afternoon, that has not been the position advanced in the district court.
DHS's position is that it all comes in front, right? Whether it's for the benefit of DHS or for the benefit of the secured creditor, right?
The department's position is that the receiver should be paid first regardless of whatever benefit is derived by any party, because what the receiver has done is come in and marshaled the property and sold it as best he can, and he should be paid for the work that he's done on the understanding based on the district court's order.
But
that
if the
he's gonna
company
be paid
beat
first.
you to the bankruptcy court before you appointed your receiver, you wouldn't be in the situation you are today. So why are you in a better position under the state law than you would be under the bankruptcy law?
Well, again, it's not so much that the department is advocating for a better position for itself right now. It's advocating for the payment of the receiver in the same way that any arm of the court is appointed, be it a trustee or in a probate context, an executor, might get any compensation that is merited to them for the work that they've done on behalf of the court.
What's the policy to give the state receiver more benefits than the federal bankruptcy trustee?
Well, I
What's
think,
the policy and why would the state do that?
you know, the state sought the appointment of a receiver in both of these cases because it was looking
Talking
at,
about the legislature, when they enacted the law, why would the legislature give this a receiver appointed under state law in a better position than a trustee appointed under bankruptcy law? And where's the policy there, and where's the support in the state law?
well, I think that the policy is that we believe that the legislative intent behind this statute is to sort of effectuate the legislature's view that it helps the Medicaid program, essentially, go after dollars that should be returned to the program for providers that are having a problem. And so it makes sense to give the receiver a way to be paid. And so I don't know that they contemplated the specific terms of and how it compared to compensation of other similar actors.
I think that's an appropriate purpose, perhaps, but your position seems to be broader than the common law rule, at least, if not slightly, perhaps more. But the legislature used language that really doesn't give us any indication that they wanted to make the common law rule anything more than what it is. Well, how can we draw from such sparse legislative language a departure from the common law?
Well, I think there's two things. One is that we look to Section 680.7, which was discussed by Mr. Borg, and Chapter 680 is sort of the general receivership statute, and it does say 680.7 lists in priority certain claims that are given priority, but it notes that before any of those are paid, the costs must be paid first, and that's also in the Bandorf case from 1994, where the court looked at a somewhat different question of when are taxes paid relative to the costs of the receiver.
And if we draw the bankruptcy analogy, they have a priority of administrative claims provision in 11 U.S.C. 507 that kind of reads like 680.7, and it's always been interpreted as not telling you where administrative claims stand relative to secured claims, right?
I'm again not because I'm not a bankruptcy practitioner. I will agree that yes, it does. But I think the reality is that in practical terms, if this statute is read the way the banks are advocating that it be read, it simply won't be an option. I mean, isn't something that the department could ever go to because, as was pointed out earlier, any receiver is going to look at the situation and say, how am I ever going to know that it interjects this question of uncertainty, that'll make it very
But
difficult
if
for
it's
any
read
receiver.
your way, the legislature now has created a mechanism to protect itself to cut off valid mortgages and valid liens, which it couldn't do in any other procedure. And that seems to be contrary to the law, the policy of the state, that people should lend money and be secure in their lending if they do the paperwork right.
But I don't know that affirming the district courts here is going to cut off. I mean, we're not saying the liens don't exist. They're not being extinguished. They exist. They just get paid after the receiver is paid for the work that he's done. So that their liens
Where does the
exist.
receiver get paid for? They get paid out of the proceeds of the property, which they had 100% right to take before the statute was passed. And that doesn't seem like the statute goes that far to cut off. I mean, what language in the statute says that secured liens are cut off by this 249 statute?
Well, the statute, it doesn't. I mean, the 249A does not address where secured lenders come in, and that's why we believe 680.7, insofar as it addresses payment of fees.
Give you an example, hypothetical. All right, I'm a lender. There's a $3 million commercial building out there that's being used for whatever, any old purpose, and I lend $2.8 million on that building. All right. Years later, somebody opens a healthcare facility that receives Medicaid funds, and they get into trouble. And you're representing DHS, and they come and put on a receiver, and you're saying the expenses of that receiver can come ahead of my $2.8 million secured loan, right?
That is how we would read it. But we would also say that, a lender who's lending to a Medicaid provider.
I mean, your rule of law would apply whether you know it's a Medicaid provider or not. You say you have priority regardless, right?
That is the way the district court decisions read, yes. And that's the position that we believe should be affirmed. And I think that what I would emphasize is that Medicaid, both in the state of Iowa and throughout the country, is a growing program, and there's growing kind of scrutiny of how its dollars are used in an effort to make sure that Medicaid is available to anyone.
Many of these small town hospitals are financed through public financing. They raise public bonds. And those bondholders have a first security interest in the property when they raise it. Well, who would want to invest in especially those small town hospitals that are dependent on Medicaid and Medicare when if there is some problem with the reimbursement, they'll never get their money back? I mean, what does it do to the whole healthcare system if you're going to make priorities over the secured creditors about even getting financing for these facilities, especially in these small towns?
Well, what I think is the realistic option for a lender is to assess this as part of a risk assessment. Lenders do actuarial assessments all the time whenever they make loans, and when you're lending to what is admittedly a highly regulated industry, healthcare is highly regulated.
That might work, except in this case, the statute came along after the loans were made.
But we go back to the common law, and I mean, our position is that this reading of the statute is supported by the common law, and so although it might not be something that arises commonly anymore, that's still the fair understanding of what happens when an entity, a Medicaid provider, is placed into a receivership, is that the receiver is paid first because they really have to be for it to have any practical application.
Well, and I guess I have another objection to that when it comes to, you were starting to answer the question, I guess, about, well, then we have to put it back on the banks, and when they start making loan decisions when it comes to financing these health care facilities, then they need to scrutinize them better, and so it really seems like you're putting all the burden back on them, and then if they're silly enough to loan to these healthcare facilities, which we all know are absolutely necessary and critical to our population, then we're still putting all the risk on them, and it's a state function, really, isn't it?
Well, when you say it's a state function, are you talking about sort of monitoring and oversight of?
The monitoring, the payment for it, it's all kind of run by the state, DHS. They kind of control and monitor all these things, and now what you're almost doing is shifting the oversight and responsibility to the lenders and requiring them to, I don't know that much about banking, but then you're going to require them to have all this additional, not only criteria for the loan itself, but then you're going to have to create another mechanism for oversight. You know, if I'm really trying to protect, under your scenario, if I could get nicked for this money, then I've got to have some type of oversight mechanism for the ongoing operation of this facility, aren't you?
Well, and I think my time is up, so I'll try to answer briefly. But yeah, I do think, that a bank or a lender to have more oversight. And the state does have oversight responsibility as part of its administration of the Medicaid program. And I guess what I would say is the state has a pretty complex apparatus for identifying overpayments and trying to find fraud, waste, and abuse, which I won't go into now. But I think a good example here is, in fact, one of these cases, the community care matter. There was an investigation going on for a long time in which the state cooperated, and a false claims action was later brought by a relator, and so the state participated in that in an effort to find those dollars, but the state is simply not able to kind of monitor every dollar that goes out the door, and they do the best that they can with their mechanisms, and we think that they can certainly know what's happening. I mean, a bank, a lender that wants to know what's going on with a Medicaid provider can make those inquiries of the provider just as the state does and requires. Thank you.
Thank you. Mr. Mellema, did you need a minute to respond to the questions?
May it please the court, counsel. My name is Chet Mellema. I'm the attorney for Morris Anderson Associates, who's the receiver in the community care matter. Just two very, very brief points, and I appreciate the court allowing the time. Morris Anderson Associates was appointed receiver on July 9th, 2014 at a hearing at the district court level for basically two reasons. One, because there was no objection by any party to their appointment, and also because they were guaranteed to be paid. And that was the consideration in which they voluntarily entered into a receivership.
Guaranteed how and by whom?
By essentially the fact that no objection was made to their appointment, and the district court's order appointing the receiver permitted them their fees and expenses priority status over any other party, essentially.
If we were to decide this case consistent with the bank's position, our decision wouldn't completely vitiate the purpose of having this receivership arrangement in the statute, would it?
In the circumstance where there's highly leveraged property, there's probably no scenario where a competent receiver is going to voluntarily offer their services without essentially a guarantee of payment, Your Honor.
But in that situation, wouldn't it be possible for the state, DHS, and for a potential receiver to make a quick determination of whether, the property is so highly leveraged that there's no feasible source of payment for the services of the receivership, and maybe it's not a good idea?
In that hypothetical, those circumstances would certainly have to be weighed. In this particular circumstance,
and can I just ask?
Sure.
So from a policy standpoint, why is that such a bad thing?
It isn't necessarily a bad thing. From the point of the receiver, specifically in the case of the CCI, we've heard a lot about benefits or lack thereof being bestowed on the secured creditors, and Morris Anderson Associates has bestowed great benefit upon DeWitt Bank and Trust and the other secured creditors. There are more in this particular case. There were 24 individual pieces of real property, almost all of them subject to leases, almost all of them involving tenants that were either challenged medically or mentally and required care. And there's essentially no third-party market for any of those properties. So to say that the banks could have come in and simply foreclosed, maybe they could have, but I think the bank's actions in not objecting to any of the proposed sales that Morris Anderson has made throughout, in not objecting to the appointment of a receiver in the first place, and essentially working in good faith with us in the negotiations in a lot of these transactions, indicates that they have received a benefit. If they're going to go ahead and foreclose on these properties, they're going to have to hire a broker. That broker is going to have to be paid. There's no third-party market, essentially, so you're looking for very specialized buyers, which in our particular case, the receiver was able to find.
Wouldn't the brokers be paid out of the proceeds of the sale as the benefit to them? I mean, if we adopt a middle ground here?
Yes, they can, Your Honor, and that's exactly what the receiver would be seeking in this particular case. The appointment order granting the receiver its powers granted a transaction fee. That would be essentially the same thing as a broker's commission. I guess that would be the benefits tangible that we would see that would be applied to the secured creditors. Thank you.
Thank you as well, counsel. Ms. Finley, rebuttal.
CCI has a little bit different view about the benefit we received. We could have foreclosed, sold our collateral, and gone home a long time ago instead of paying so much money in the fees in connection with this receivership. And the receiver in this case sold the vast majority of the assets to a tenant and third-party manager that was already in place before the receivership was established. And a lot of the other sales that have happened have been on account of the efforts of DeWitt Bank. Now, that being said, there's no question, as we discussed in our brief, that there is a common law exception to the extent it can be demonstrated that the receiver's actions were taken for CCI's benefit and Bank Iowa's benefit, and it preserved the collateral and maximized their recovery, then yes, that tracks the bankruptcy code, which says usually the liens won't be touched. The cost of the trustee will not come from the liens unless the trustee is acting on behalf of the secured creditor to protect the collateral. Here, the trustee has not only not tried to protect the collateral, has forced us to litigate continuously about whether or not he can avoid our liens. Now, the other thing that we never consented to a receivership where we would shift the risk to our paying, that would shift the obligation to pay for the receivership to us. And the idea that that the receiver was not aware of the super priority issue is simply a little disingenuous. Once we saw the word super priority and that seemed to suggest that the receiver might be taking before our liens, we immediately intervened. And the receiver was aware of this super priority issue before its appointment because Bank Iowa, who had been involved in the Morse case, had brought it up. So we would disagree a bit with counsel's characterization of how this came into being.
Well, I don't know if I'm looking at the right order or not. I assume it's the July 9th, 2014 order. Is that the one we're referring to?
Yes, Your Honor.
And again, I'm just looking at the recitation by the court in that case that said after discussing it all, all parties agreed to the appointment of a receiver and allow super priority status to all property to which Bank Iowa does not hold a security interest. So they were kind of carved out at that time, weren't they?
Okay, that's Bank Iowa. I'm CCI. We weren't a party, and we weren't aware of this issue. We just simply weren't aware that that was the position they would be
As I
taking.
understand in your case, in the DeWitt case, the Bank Iowa case happened first, so
Yes.
Bank Iowa was aware of DHS's position.
Yes.
So then when it got to your case, they were able to get involved early on, and sort of to buy peace with them, DHS agreed that their lien wouldn't be touched,
Right.
and your client wasn't informed of what was going on, and then as soon as you
And
knew,
as soon as we were, 6 days later, six
you
days after the order.
intervened. And you have, in that case, you have the much bigger security interest, is that
Yes, we have about $3 million worth of collateral at risk. The lenders aren't trying to exploit the receivers. The reason that there's so little case law on this, secured lenders almost always work to figure out a way to make sure that the receivers are going to get paid. However, again, in most cases, the receivers aren't trying to avoid the liens. Hang on. I wanted.
What's the total amount of the receiver's charges thus far in the DeWitt case, in the CCI?
Well, and this is outside the record, but again, we have always said that there were sufficient assets to pay almost, all or almost all. I believe, and it's not clear from the report, I believe there's somewhere between $600,000 and $700,000, and that there would be sufficient unencumbered assets to cover those. And that's another issue. The state, said it was not.
Did you say that most of those assets in the DeWitt bank case ended up being taken or acquired by the tenant?
By the existing tenant
Yeah.
and third-party manager that was in place before the receivership was established. The state offers no justification for shifting the costs of the receivership to the banks. And to the extent that it appears that this receivership is benefiting the state, it would be the state who would be the better party to pay that. And my time is up. I'm sorry. Do you have any other?
Thank you, counsel.
Thank you.
These two cases then are now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.